wanted to do was hear the arguments in regards to the defendant's motion for permission to call witnesses. I know that this was filed this morning, but it's kind of hand in glove with issues that were raised a couple of weeks ago. At least mention the same witnesses. So I'm going to hear first from the defendant. They'll hear from the Commonwealth. I will probably take it under advisement and review some of the other documents, but I want to make this decision as soon as I can, so everybody kind of can plan on how they go based on the decisions.
The judge appeared ready to let the defense bring in new medical testimony, but there was one major limit. The defense argued that these medical opinions were necessary to challenge the prosecution's case against Lindsay Clancy.
Your Honor, obviously, I don't have to belabor the obvious. This is a murder trial, very serious business, and we've all been working very hard on the discovery, which, as you can tell, is voluminous. Hundreds and hundreds and hundreds of pages of state police interviews. And I mentioned, about with the government. They have cops. They have people going out and interviewing. They have videos. They have chemists. They have detectives. They have local cops. They want a cup of coffee, they can send 5 cops down the street to get one. I'm it, except for my son Patrick, who helps me out getting coffee, all right? And the reason I sound frustrated is that they are objecting 2 weeks ago because they need time to review, to cross-examine doctors on very basic items of evidence that are their items of evidence. Not one of those witnesses is adding or bringing anything new to the discovery, if you will. And not by way of excuse, but, I am a sole practitioner. In the past, May, June, July, in the past 3 months, I've had a murder, a rape, and 2 back-to-back federal trials that ended 1 week before we impaneled on this case. I have worked really hard to pull this case together with expert witnesses, civilian witnesses, private investigators been investigating. I provide everything to them as soon as I get it, and they have been doing the same with me. I haven't objected to one thing that they have offered. They put an AutoCAD, computer animated display disc on my desk last week. I didn't complain about it, run to you and try to exclude it. I said, fine, no problem, put it in my pile and move on. That's it. So to suggest that they need time to be able to cross-examine both, I've had trials with both of these prosecutors. They're both experienced. They're very, very familiar with the trial of major criminal cases. I feel that they're more than capable of being able to cross-examine, for example, number one, Dr. Volkovich, who is a board-certified emergency medicine physician. His report indicates that he has taken a look at South Shore Hospital. He's taken a look at the Brigham and Women's Hospital. He's taken a look at the photographs. That's their evidence. That's all he looked at. And all he's doing is basically what all of their South Shore doctors came in and testified to as to the nature of the injuries, in his opinion, the type of injury that she suffered, talking about the injuries to the right and left wrist as well as the neck. In his opinion, dealing with suicide attempts, that it's a legitimate suicide attempt. There's no secrets. There's nothing new that they have to prepare to cross-examine him on. Dr. Laposada is a doctor that is well known to most of us, and I've been using Dr. Laposada's fine services for the past decade or longer. I know that both of these attorneys are familiar with her. She's not bringing anything new to the table. She's bringing her opinion based upon their evidence as to the medical records, x-rays, all of the rest of the indicia of the injury that she suffered. Now, they're talking about Lindsay going out and hanging off of a window and then doing, like I said, the Spider-Man slide down the side of the house, apparently. Absolutely ridiculous. She dove out that window, she hit her head, and she suffered what Dr. Laposada refers to as a Jefferson fracture of the spine that is very, very, very typical for this type of an injury. When somebody dives into the shallow end of a pool, they get that injury, unfortunately. When somebody Kids are on a boat and they're drunk and one of them jumps off a mast into the shallow end of the water off of Cape Cod. They get that type of injury. Superman, when he gets thrown off the horse, 6 feet high, same injury. That's all. She's not bringing any esoteric theory to this case that they need time to prepare. Interestingly enough, the Brigham and Women's Hospital records do make reference to the Jefferson fracture, right from jump. She also assists me, as she always does, on autopsy photographs, any indicia of injuries, and it's her opinion that if they try to say that there are bruises to these little babies that were inflicted by her, they're absolutely wrong, and Dr. Laposada would indicate that these are consistent with either EMT, God bless those first responders, but they were in a panic and they're trying to take care of these kids and pick them up and run them up to their trucks and vehicles. So, and other, obviously, the interosseous injection into the legs, the shins, the thighs, all of these bruises are from medical intervention, not Lindsay Clancy. That's what she would testify to. That's it. They don't need time to prepare to cross-examine for that. Finally, I have Dr. Condi. Dr. Condi signed even better than a report. He signed an affidavit. And again, it's based upon medical records that we all have. Way back when this case first started, the government presented the case to the grand jury. First thing I said to Lindsay was sign a release. Let the government get all the medical records. We'll all have access to them. This case is obviously going to be predicated upon the medical records, psychiatric records. We signed every release. They got every document and had them into the grand jury. I got copies. They have copies. Condi would testify to the horrific, in his opinion, failure to comply with the standard of care that would govern psychiatrists, psychologists, Dr. Tufts, who's going to be testifying tomorrow, nurse practitioner Gelada, the other individual from the McLean Hospital, all records that they've had for years. So they don't need time to prepare for cross-examination. So weeks ago, counsel, after I gave them copies of all of these reports and affidavit, strike that, I'm sorry, the reports I just got, and I just sent them the affidavit from Condi they already have, I disclosed to them what my opinion would be of the opinions from these doctors that would be testifying, and the report carries that out. I suggest to the court that to strip Lindsay's ability to present evidence in support of her defense, number one, it would not be in the interest of justice. I'd like to hear a DA stand up and say, in the interest of justice in this case, because weeks ago we got this information and we're not prepared to testify, to cross-examine the testifying witnesses, I think even Your Honor would agree is a disingenuous argument. She came in and said to you, oh, Rule 14 matters, and it applies to the government just as it applies to the defense, and therefore you should exclude these witnesses. Well, if I messed up and it's my trial schedule that caused me to not be able to have written reports of the stuff that they've had for years to prepare to cross-examine these witnesses, then it's my fault, and it deprives her of effective assistance of counsel, because that would then deprive her of her defense. This is a pathologist, an emergency room doctor, and a doctor who would testify to the standards that would apply to these doctors that they're going to call as their witnesses, which is another interesting fillip, if you will, where they're calling Tufts, Gelada, the other individuals from McLean, all treating physicians of her that are all lined up to come in and testify against her on this case. Fine, bring it. But at least give me the ammunition to counter it.
Let me ask you this, I kind of go backwards. In regards to Dr. Condi, the affidavit really speaks more towards the standard of care.
That's right. He's not giving an opinion of criminal responsibility.
Right, but I'm struggling to see how that comes in. Now, maybe.
Well, he's the doctor that I'm using for toxicology.
That's what I figured. But the reason I'm asking that is I'm not sure in this case, is this the standard of care necessarily as relevant as to, in regards, as opposed to causation? Do you know what I mean?
Well, yeah, I think the standard of care does speak to causation. He doesn't have to use it as standard of care. He can use it as his opinion as to the first doctor that she spoke to, Dr. Tufts, when she presents with a bipolar 1 presentation, and then Tufts prescribes an SSRI to her, which flies in the face of any rational psychiatrist and what they would prescribe and do. He's more than qualified to testify.
That's a different question, and that may be more admissible than someone saying, oh, I found what the standard of care, and I find that this violates it. If we have got an expert who says, listen, I am qualified, I looked at these records, I disagree with that treatment, I'd be more inclined to allow that than to get into the standard of care, which is obviously consistent more with the civil world.
So with that, I can reach out to Dr. Conde and have him delete reference to standard of care in his report and address the actual treatment as to an opinion as to its appropriateness. But again, on the issue that they're raising, that they need time to prepare to cross-examine, I don't think that lies even if he revises his report by removing standard of care.
Well, let me ask you this, because I haven't had an opportunity. This is probably what I'm going to have to look at tonight. Is Dr. Conde adding anything to the expert disclosures that have already been made? Because I know there's disclosures.
He's taking the medical records, Tufts, Gelada, McLean Hospital, and just commenting on the care and the treatment that was presented to her as a patient looking for help. That's all he's doing. He's not adding anything. He's talking about the prescriptions that were provided to her, the SSRIs, the antipsychotics, the benzodiazepines, all of that. That's what his opinion is predicated upon, which is all of the prescriptions that the government has already introduced into evidence and is well aware of.
Right, I understand, but I know that the parties have already exchanged reports months ago, and I know that everybody did that. And I haven't had a chance to review specifically the defendant's reports. And is there an expert who is going to address these kind of issues already?
No. Dr. Conde was my toxicologist and my physician that would give an opinion as to the appropriateness of the treatment that she received, especially as it relates to the prescriptions. I mean, Dr. Laposada is a pathologist. She has nothing to do with it. Dr. Zeisel is a psychologist. He has nothing to do with it. Dr. Resnick is a psychiatrist specializing in infanticide. He's not addressing that issue, and nor is Dr. Spinelli, who is a postpartum depression, postpartum psychosis expert. So Dr. Conde is my expert for toxicology and level of care that she received.
Didn't we have multiple trauma surgeons, neurosurgeons who've testified, who treated her? Couldn't someone just ask, is that consistent with, and that's pretty much, if I'm looking at Dr. Laposada's note, I'm not sure I would allow in opinions regarding whether or not it's a serious suicide or not, but she does indicate it's consistent with landing on an individual's head.
So what do you think? Should the defense have been allowed to present these experts? Or was the judge right to limit their testimony? Let me know in the comments.